Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I also have a good topic for you. So, if your spouse is threatening to get you deported, what should you do? Yes, this does happen, and my number one recommendation is that you take it into your own hands. You take control of your situation, and there is always the option to apply for VAWA or even other forms of relief, right? You don't, now in this case, for example, if your spouse is a US citizen or a legal permanent resident and they're threatening to get you deported, then you can go ahead and use that to apply for VAWA because no spouse is supposed to be using your legal status against you. If they're doing that, then that's abusive. That is mistreatment. That's extreme cruelty. And so you can go ahead and apply for your own relief, even if you're out of status, even if you cross the border without permission. Once that comes out of your spouse's mouth, then it means that they're not for you. They're not supporting you the way that a spouse should support you. And you can move forward in other ways. Because based on my experience as an attorney, when a spouse starts to issue threats like that, it does not stop, and they likely will not see you get that green card. They will get to the point. They will sabotage you before they see you getting that green card. So once that threat is issued out of their mouth, you want to make sure that you protect yourself. Now, I did mention that there are other forms of relief, right? So, for instance, if say this spouse is not a U.S. citizen or a legal permanent resident. Say they themselves, maybe they have a visa, maybe they don't have permanent residence or citizenship, or maybe they themselves are out of status, but they issue a threat like that. Then it comes down to, do you qualify for other forms of relief based on this threat? Usually, when they are issuing threats like this, they're trying to force you to comply with them. They're trying to control you. And in cases where they're trying to control you, to get you to do things against your will, there is the ability to apply for the T visa as a victim of trafficking. Because when someone tries to compel you to do, so say they're trying to compel you to give them your wages, to go work and then give them your wages. If they're compelling you to do work in the house or to take care of their children or to do tasks that you did not want to do, but you feel like you have to do because now they're issuing this threat, then that's a form of labor trafficking. And also, if they are trying to force you to do acts against your will, like sex acts, if you don't want to have sex with this individual, but they start to issue threats like this, and you feel like now you have to comply, in exchange for your own safety or in exchange for shelter or food or to make sure that you can gain access to these things that you need on a day-to-day basis, that's a form of commercial sex trafficking. Yes, it is not just in the sense of, say, usually when individuals hear commercial sex trafficking, it's a situation where a pimp or an individual takes another individual and then exchanges money to, say, John's, in for sex, right? To for the individual to perform sex acts. That is a form of sex, commercial sex trafficking, but it is not the only form under sex trafficking. If Even if this person is a spouse, even if they're an intimate partner, but now you find yourself in a situation where they're forcing you to do these things for them in exchange, and they don't have to say, hey, do this for me and I'll give you this, but it's implied, right? Or they say something like, if you don't do this, you will not, you have to get out of this house, or you can't have access to your children, or you can't have the food in my house and you don't have money to go get food elsewhere, you don't have a place to go stay, well, you're going to feel forced to do this act that you don't want to do to be able to get the necessities you need to survive on a day-to-day basis. That's a form of commercial sex trafficking, and under immigration law, you can get relief based on this, right? So even if it's a spouse, even if it's an intimate partner, and they are forcing you to do something like this, it can still be considered trafficking, whether labor trafficking or sex trafficking. So if you're usually in a situation where a non-citizen or a non-resident or a citizen or a resident, they are issuing a threat that they're going to get you deported, it usually is followed by, if you don't do this, right? Or if you don't do this, I'm going to get you deported, I'm going to report you, so you need to do this. So it's a form of blackmail. And of that, we are able to not only look to VAWA for relief, but also other forms of relief for you to gain status here. So let's go back to VAWA for a minute. Now, remember with VAWA, it's if you have to be married, legally married, or in a legally recognized marriage, as in it could be a common law marriage, but it has to be recognized by the state that you're in. State or country that you're in, or where you had the common law marriage. Now, if you're in this situation, you first have to be legally married. You have to show that at some point, not necessarily during the marriage, but at some point you were living together. And then you also have to show that you experienced this mistreatment during the marriage. Now, in this case, the next question is, can you apply while you're still living with this person? If you're still living with this spouse, you're trying to find an exit plan, but you cannot leave just yet, or you feel as if you can't leave, the answer is yes. While I always say that a client should make sure that they put their safety first and prioritize their safety, if they're in a situation where they need to get the VAWA done, we do help our clients to get this done safely. What we do is we make sure that all correspondence comes to our address. It's called the safe address. And that way it never goes to the home that you're sharing with the abusive spouse, or the spouse who's mistreating you, or the spouse who's issuing threats like they're going to get you deported. Then we correspond with our client in order to exchange any documents that will be important to them, like the prima facie determination letter, or like the work permit. So the work permit or the travel document that they need. And oftentimes this can be a part of the exit plan. Applying for their own immigration relief can be a part of an exit plan, because when they are able to know that they are going to get a work permit, or that a work permit will come to them, they're able to find a job and establish independence, and then move on that way, right? Because now they have a job, they have money for themselves, that they're able to then leave the situation, or leave the situation shortly before receiving these benefits, and then gaining that independence along the way throughout the rest of the process. So one advantage here is that you can apply even when you're with the spouse, but we do it safely, and there is a way to make sure that it's done safely. The immigration service will not call your spouse. They will not ask for permission. They will not ask them to sign off on what your statement, what you've gone through. They will never disclose it, or they should never disclose it. It's against the law for them to disclose anything about your VAWA matter outside of the agency. So this means that you are in a protected situation. Now, if this person is threatening to get you deported, applying for VAWA also puts you in a sort of protected status. The reason being, once you've applied for VAWA, they are now on notice. The Immigration Service is now on notice that you're experiencing abuse or mistreatment by the spouse. And that means that one, they will not disclose any information to the spouse, even if the spouse calls, even if the spouse writes a letter, that they will not issue any information to that spouse. And then the other is that they cannot use any statement submitted by the spouse to make a decision. So it puts you in it protects you from sabotage, from any kind of sabotage that the spouse is trying to carry out against your application. So that's the other advantage. Now, while VAWA, to get from filing to the green card, it is taking about 2.5 years. Hopefully, it will go faster because they have now designated a new service center. So they used to just have one service center called the Vermont Service Center who did all of the VAWA applications. Now they have two service centers that are processing it. So hopefully we'll see a faster processing time. Um, but for now, I am telling my clients to expect about a 2.5 year wait to be able to get permanent residence. But the other advantage here is that you are able to continue to have a work permit. Work permits are 2 years. So you're able to have a work permit, social security number, throughout this time, and they do continuously reissue a prima facie determination letter, which can help you to get benefits, public benefits, throughout your process. So you are able to, get a head start on life. And this is your process. You don't have to worry about anybody, especially that spouse coming in to destroy your process, or you don't have to be dependent on them, especially when they not only are threatening to deport you, but they're also threatening not to show up to that interview. Well, in this case, there will be no interview that that spouse will have to attend. And so this belongs to you, and that means that it puts the ball in your court, and you have that control. So that's the other benefit here. The other is that you don't need an affidavit of support. So, one of the major aspects of applying for through marriage-based process is that you do need to make sure you show income requirements, that your petitioner, which would be the spouse or a co-sponsor, can meet the income requirements. They can afford to support you, and in this case, it is not required to submit this affidavit of support. So it means that you don't have to face that threat, that you don't have to face that additional stress of having to now show how you're going to pay for your own residence here in the United States. That becomes a non factor when you're applying for this type of application. They also don't hold against you taking public benefits. So if you have to take food assistance or medical assistance, you will not be penalized in any way for taking those, as long as, of course, you do it in an honest way, there's no fraud involved, and you do indeed qualify, that you didn't have to misrepresent any facts to be able to get those. So that those are, in a nutshell, those are the benefits. And you know, I'll tell you something that's a benefit that's not necessarily um, related to the immigration process, but to the individual. When I am watching my clients, I observe my clients from the time we've started to the end point. When we start the process, my clients are very distressed. Understandably, they're anxious. Sometimes they are very run down, and you see it in their physical appearance that they are really depressed and stressed out. They may be in a situation where they're being mistreated, so they're not paying attention to their own health and well-being, and you see it on the outside. But as we continue through their process, and as they get the benefits of the VAWA, which would be the work permit, and they get the travel document, and they're able to start working, and now they can remove themselves from the situation. They can move out or move away without any fear of being deported, because now they know they have this VAWA process, and so they're in a situation where they're insulated from any kind of you know deportation, and that while the process is going forward, they start to flourish and they start to glow. And it gets to the point where I may get calls from them frequently, and then it stops because they are in a comfortable position, they're reassured, and they are now focusing on themselves, thriving and moving forward. And the only thing that they have left to move forward, to look forward to in the process, is getting the green card. They don't have to worry about what is this person going to come and do or say to them. They don't have to worry about constant fighting. They don't have to have anxiety about their children and the safety of their children. They can just focus on themselves and get themselves in a very stable situation to thrive in the future. So that's the most rewarding part of this, is that I see the what my work does for an individual as they go through the process, and they see how much benefits they get out of this. Emotional benefits, they get to heal, and they get to move forward, they get control, right? So it's very gratifying to see that. And any one of my clients would agree with that, right? So if you're going through a situation like this, go ahead and go to the link in the profile, schedule your appointment, and we can get straight to work. Now is the time. Now is the time to get it done. On a side note, things are changing in the political arena. For example, I am here in Florida, where they are coming out with bills that are targeting immigrants, undocumented immigrants. And we're hearing this rhetoric all around. Now, at this time, we do have an administration who is they're trying to make this system fair and just for many immigrants, especially immigrants who are going through situations like this. And because of that, they have new policies that are in place to facilitate the process, to make it better for victims of this type of mistreatment to come forward and to get the benefits that they deserve. This can change just depending on what direction we go in next year, November, right? So towards say January, when if the next administration takes over, I hope not, but they are not for immigrants like this, then it means that policies could change. And if you start too late, it means that you will not be able to take advantage of how they're trying to make the system fair and just for immigrants who deserve this kind of relief. So get started now. Don't waste time. It is urgent at this point to make sure that you take action to get the relief now. Get started now. Remember, this is about a 2-year process. And so you definitely don't want to start this later on, where now the individuals who are making decisions have to follow different protocols, different policies, more stringent, and policies that are more anti immigrant. So you want to start now when the time is right now. Okay, because and this goes also for the T visa for victims of trafficking that I mentioned earlier. If your spouse is not a US citizen, they are not a permanent resident, but they are threatening to get you deported, or they're doing other things like trying to force you to do things that you really don't want to do, then you can also qualify for possible other types of relief like the T visa. If you are the victim of domestic violence, you should get in touch with me and we can evaluate your options. If your spouse is mistreating you in any way, talk to me. Give me a call, schedule an appointment, talk to me, and we can evaluate what your options could be, what to pursue as soon as possible. All right. So now that I've gotten through what I have to say, I'm going to go ahead and open up the floor for you to put your questions in the comments. I'm already seeing a number of questions coming in, so I'm going to go ahead and scroll through and answer those questions. Um, so go ahead and put those questions in now. Thank you so much for the love and thank you for your time. Now, tomorrow, I just want to give you a heads up that I will not be on the live tomorrow because I do have an engagement. I will come back on Monday, but I will not be on the live. So if you want to get your question in, get it done now, put it in the comments. I'm trying to scroll to the top to answer questions. So let's see. What should I do after I got deported and I have a child? So it's what you should do depends on the reason for the deportation. For example, if it's if you were deported but you're subjected to a ban of more than 10 years, then we have to see how long have you been outside of the US. It also depends on what you were deported for. If you're deported for something where you're permanently barred, you have to be outside of the United States for at least a certain number of years before you can submit your application for reentry. Another thing is in some cases where you can qualify for a waiver, we have to look at whether your child can be a qualifying relative or if you have other relatives who you can qualify. If you have other relatives who can help you qualify. So it's a very complex topic. When you've been deported, we have a number of follow-up questions we have to ask to get to the bottom of your solution. I'm a victim of the same topic. I went through tough times with my spouse. I'm so sorry that happened, and I hope you're on the other side. If you are not, give us a call. We will be more than happy to help you. What is the average timeline after VAWA approval before green card? So it's taking about 2 years to get that VAWA approval, and then afterwards, about 6 months to another year to get the green card. So I'd say on average, 2.5 years. If you file for minor from Jamaica to the US, can the case be transferred to the US and will the processing time start or wait time start over? So if the child, so it depends. So if it's at the embassy and then now your matter is here, then you could file for adjustment of status with the child. But I would need to understand what's going on here, right? Because it may be as simple as applying for adjustment of status, just where you are in the process, but it may not be because what is your status as the petitioner? What's the child's status in the United States? Are they in status or out of status? So give us a call and we can definitely help you from there. Thank you so much, Denroy. All right, let's answer some questions here. Do you get travel documents while waiting for VAWA to be approved? You can. You can apply for the travel document. If you're waiting for VAWA to be approved and you've applied for adjustment of status at the same time, then you can certainly apply for a travel document as well. Usually, when I am representing my clients, I apply for everything. So their work permit, their travel document, their social security number, all together. All right. So I don't see any more. Okay. So I do see one here. My children were approved without any hassle, while my wife's petition is still being actively reviewed. So yes, unfortunately, they do process the children's separately from your spouses, because I don't know if you're a resident or a citizen, but if you filed each petition separately, they are going to process them separately. So there may be a discrepancy in the processing times, and it's just one of those things that are beyond the control of anyone but the USCIS. All right, put those questions in the comments. I will not be on the live tomorrow, which is Friday. I'll be back on Monday. So go ahead, put your questions in the comments so that I can answer your questions now. Now, if you would like to get in touch with me, go ahead. The best thing you can do is schedule a consultation to get the answers and the assistance you need for your process. Go to the link in the profile where you will see everything you need on Instagram, on YouTube. In the description of the video, you'll see the link that also leads to everything else. You'll see a button to schedule your own appointment. You will see button to go to the website. On the website, we have online chat. We have the contact form, and then we have a button where you can call and talk to staff if you need assistance to schedule your appointment over the phone. What's the difference between dismissal and termination? So termination, usually when they terminate it, it's usually with a dismissal, and termination can be without prejudice, meaning they can always bring another case. Now with dismissal, if they dismissed it, it possibly means that they don't have any evidence to move forward. But it can always be without prejudice, meaning they can always bring back a case against you. Now, nowadays, they are terminating some cases, and it just means that they've ended the case. There's no moving forward with it, but they may bring it forward. So, with dismissal, it's more of a procedural where it may be an evidentiary issue and where you could ask for a dismissal. But with the termination, all parties usually agree to terminate the case. Um, all right. My husband is a citizen and he filed for me and my son that is in a foreign country. I got my approval letter. However, my son's filing was sent back. It said I need to file his I-485 as well. So, oh, you would have to call and schedule a consultation, because we need to know where your son is. An I-485 can only be filed in the country when you're here. If your son is outside of the United States, then they go through consular processing. So I'm not sure what happened there. Um, any update on I-601A? Been waiting since 2021. There is a lawsuit that's pending right now that's trying to tackle how long the processing times are. I've not heard anything about the lawsuit and how it will, but hopefully it will speed things up. Um, and of course that benefit will go to others who are not involved in the lawsuit, but nothing new right now. Is that how it works now? So we're talking about if your son is outside of the country, they should not be telling your son that he needs to file an I-485. I-485 is an adjustment of status application that enables you to be in the US. So that's not how it works. If your son is outside of the United States, it will be approved and sent to the country where he is. So, what I would say here is get representation, especially when in doubt. When you receive a prima facie determination, what is the next step? So it's a waiting game from there. So usually you'll either get your biometrics fingerprinting appointment to do your background check, and then your work permit will come. Once your work permit comes, then it's waiting for the approval. You might be issued two, three, maybe even four of these prima facie determination letters over the course of the time that it takes for them to make a decision on the VAWA. They will automatically issue these prima facie determination letters. And then at that point, once you get a decision and you file for adjustment of status, they will then consider you for adjustment of for the green card. What if you don't have anything joint? Can you still file for VAWA? Yes, absolutely. I do have clients where that happens, and that happens often in relationships where there is an unbalanced power dynamic and one is mistreating the other. You usually find situations like that, so it is not strange. The best thing you can do is get in touch with us, give us a call, and get started. All right. So, Queen, what I would say is get legal advice. Don't try to do this on your own. Because if your child, if your spouse filed for both you and your child on the same application and your spouse is a citizen, that would explain what is wrong here. Is your child is not cannot be included on the same application. So that may be why they may be saying file a separate I-485, but the I-485 is only when your child is in the US. If they're outside of the US, your spouse has to file an I-130 first. So at this point, I always say, wouldn't you want to make sure that you are doing this correctly to avoid year or two of delays and nightmares and mistakes? If that is the case, make sure you get assistance, especially when you have doubts about these kinds of procedural steps that you have to take. Guessing is the worst thing you can do. Um, okay, so I got dismissal without prejudice going to file VAWA through USCIS. Is it safe to travel outside with travel documents? So I cannot advise you specifically because I'm not your attorney. Make sure that if you do have an attorney, that you talk to your attorney. But what I would say is when I'm talking to my clients, and based on what the information you've said right here, that is very risky. If you have not even filed for VAWA yet, you've gotten this dismissal, it means that they could bring forth deportation at any time. And so if you leave the United States with a past deportation, even though there was no final order of deportation, they could see it as self deportation where you got up and left the US. And so it could complicate your case when you're trying to get back in and they're seeing that on your past record you had a proceeding against you for deportation. So when it comes on to situations like this, where the risk is higher than normal, I would usually tell my clients, do not travel. You don't, it's much better fighting to get status being in the US than being stuck outside of the US. So while I can't tell you the same, I would say if my if my client had a deportation proceeding that was dismissed without prejudice, I would tell them to stay put. All right, that's going to be it for me. Thanks so much for your time. I will be back, not tomorrow, on Monday, to be able to, um, bring a topic and also answer your questions. So I'm looking forward to speaking with you on Monday. In the meantime, have a good weekend. I think of some more questions for Monday. These were all great questions. And then we can, in the meantime, look out for content as usual, videos that may be of interest to you. And it can give you good information, give you some good tips. All right. Have a good one. Bye bye.